Hello everyone, and welcome back to our channel. Today, we're diving into a riveting court case that has been making waves in the legal world. Buckle up as we journey into the intricacies of a case that has had significant implications for Australian immigration law. Our story revolves around an Iranian citizen who found himself at the epicenter of a legal storm. This citizen, arriving in Australia by boat in 2013, sought a safe haven enterprise visa, commonly known as SHEV. However, his application was met with refusal, the primary reason being a prior conviction of people smuggling. This case serves as a stark reminder of the complexities involved in immigration law and the significant impact that prior convictions can have on an individual's ability to seek refuge. The refusal was based on the fact that he had been convicted of people smuggling. The plaintiff arrived in Australia by boat in 2013 and was immediately detained. 4 years later, in 2017, he sought a chance at a new life by applying for a Safe Haven Enterprise Visa, or SHEV. However, his application was summarily refused, owing to a previous conviction. The refusal was not arbitrary but based on a specific clause in the law, Clause 790.227. This clause, in essence, states that granting a visa would not be in the national interest, particularly in cases where the applicant has a criminal record. The Minister for Home Affairs, in refusing the visa, relied heavily on this clause. Her decision was rooted in a belief that granting such protection visas to convicted people smugglers could potentially undermine Australia's stringent border protection measures. Furthermore, she feared it could erode public confidence in the visa program. The minister's refusal hinged on her belief that granting protection visas to convicted people smugglers would undermine Australia's border protection regime and potentially erode public confidence in the visa program. But here's where things get interesting. The plaintiff argued that Clause 790.227 should not permit the minister or delegate to reconsider matters already considered under Section 65 of the Act. He believed that this clause was being misapplied, used as a catch-all to refuse his visa on grounds that had already been evaluated and dismissed. This was not just about his own application, but a broader concern about the misuse of power and the potential for bias in decision-making. At the heart of this argument was a question of fairness and correct legal procedure. The plaintiff contended that the initial assessment under Section 65 had already considered his past criminal conduct. Therefore, to refuse his visa on these grounds again under Clause 790.227 was not just double jeopardy, but a misinterpretation of the law. He contended that Clause 790.227 should only come into play when there are other considerations against granting a visa. And guess what? The court agreed. The court's decision hinged on the interpretation of Clause 790.227. They asserted that this clause was not intended to be a trump card for the minister, but rather an additional basis to refuse the visa if there were other compelling reasons against granting it. The court found that the minister's reliance on this clause to refuse the visa solely based on the plaintiff's past conviction was a misapplication of the law. This was a victory for the plaintiff, but it was more than that. It was a reaffirmation of the principles of justice and fairness that underpin the legal system. The court's decision was a clear message that every individual, irrespective of their past, is entitled to a fair and unbiased assessment of their visa application. In a stunning turn of events, the court ordered that the decision to refuse the plaintiff's SHEV application be quashed and commanded the minister to determine his visa application according to law within 14 days. And that, folks, is how one man's fight for justice led to a landmark ruling in Australian immigration law. A determined individual, undeterred by his seemingly insurmountable past, challenged the system and won. This case serves as a testament to the power of perseverance and the importance of justice. The court, in its wisdom, did not let the minister's preference overshadow the law, but instead insisted on strictly adhering to it. It's a stark reminder that, even when faced with daunting odds, standing up for what you believe in can yield surprising results. This case has not only changed the life of the plaintiff, but also set a new precedent in Australian immigration law. It's proof that the voice of a single person can echo through the halls of justice, prompting change and progress. So what do you think about this case? Was justice served? Let us know in the comments below. And don't forget to like this video and subscribe to our channel for more legal drama breakdowns. Until next time.